So today we're going to talk about Métis rights, and we're going to do the same next class. But before I do so, I want to just remind you that those who are writing your papers have a quiz that you'll receive Tuesday, November the 10th. So not Tuesday tomorrow, but Tuesday a week from now. And for those who haven't yet filled out this form with their email, please make sure that you do so that when the time comes on the Tuesday for me to be able to send along your quiz, you'll get that in your inbox without issue otherwise. So what I'll do is I'll send this around just to make sure that you're signed up for this. If you didn't get this before, I hopefully can remember to do the same thing on Wednesday so that everyone's taken care of. You can just take that and pass that along. Are there any questions about the quiz or the papers at all? I think now everyone should have submitted me your paper outline. I will have given you some feedback in writing. I know some of you have also come to speak with me. I welcome anyone who is writing a paper to come and speak with me about the direction of your paper, and look forward to helping you figure out the scope of that as you're working through. As you continue to write as well, I would also hope that if a question arises, you'll just also send me an email or come and see me so that we can make sure that you don't stress out for the getting of this done. Okay, so today we are going to talk about Métis rights, and the first part of the readings talk about different ways that Métis people can be identified. And by and large, there was two potential theories when Section 35(1) of the Constitution was passed. One of those theories saw Métis people clearly in terms of the Red River settlement and those people who are ancestors of the people that were settled at Red River in the 1870s. This idea of the Métis is in accordance with something called the Métis Nation of Canada, that has a particular homeland and that there's a diaspora that has worked out and from beyond that homeland. It's a Western Canadian-based understanding of Métis, and there are particular qualities that this Métis nation developed. For instance, the Michif language was one part of it, and I can't remember which way this occurred, but it was a combination of French nouns and Cree or Ojibwe verbs, or vice versa. I just can't recall there. But it was a new language, not just what they call a pidgin language, but a new language that developed on the prairies as a result of this intermixture of the two language families in this accord. And there are still people who speak Michif and find that as a part of their identity, their way of expressing themselves in the world. They also have a distinctive song culture. If you go to some of the websites that were reproduced in the links on open course space, you'll find a lot of jigs and reels that are part of a phenomena using fiddles and etc. that really express part of their energy and being in the world. Also many stories that they had about their own distinctive genesis and place in the world. And then they have laws that they gave, not just that flowed from their creation story, but also from their time living on the prairies. One of the things they did was they would go out from the Red River settlement where they had agricultural farms along the side of the river, and they would go buffalo hunting through Manitoba, Saskatchewan, what become Manitoba, Saskatchewan, Alberta. At the time this was, in Canadian terms, Rupert's land. It was they also went down to Montana and the Dakotas and Minnesota, and they would go out for a season on the prairies, and then they would come back. In order to do that, they would have to organize themselves. Obviously, they needed law. And one of the laws was that they had a law of the buffalo hunt. And here are some of the provisions that they wrote down as a part of this. They had a captain of the hunt. This captain of the hunt could impose penalties if the laws were broken. They included things like this: no buffalo to be run on the Sabbath day. They were often French fathers who were Catholic, And so Catholicism became a part of the way they organized their affairs. No party to fork off, lag behind, or go before without permission. So they would travel as a group. No person or party to run buffalo before the general order. Every captain with his men in turn to patrol the camp and to keep guard. For the first trespass against these laws, the offender was to have his saddle and bridle cut up. For the second offense, the coat was to be taken off the offender's back and be cut off. For the third offense, the offender was to be flogged, the kind of thing that was happening more generally in England at the time, in France. And any person convicted of theft, even to the value of a sinew, to be brought into the middle of the camp, and the crier to call out his name or her name 3 times, adding the word thief at each time. Right, so incentive-based laws here as well. These laws of the buffalo hunt were obviously necessary because you can't have, hundreds and thousands of people on a venture like this without having some sense of order. So there very much was a positivistically based or declarative base of law, in addition to the customs that were part of the stories, song, and language. But there was another definition or claim to being Métis at the time that Section 35.1 came into effect, which is that any person is Métis if through intermarriage they share some of these qualities. That is, that they self-identify as Métis, that they have a connection to a Métis community, and that there's some kind of community acceptance of that self-identification of an individual with that community. Now this, in fact, becomes the definition that is going to be talked about next class when we read the Pauli case, because there were and are Métis people that have their genesis from places other than the Red River. And in the Pauli case, you'll learn that one of those places of genesis is on the Great Lakes. And so north of Sault Ste. Marie, there were Métis communities that developed there between Ojibwe and French and English people that had quite a significant history of developing their own language, customs, traditions, laws, access to resources, relations with the Indians that were separate, relations with the French and the English that were separate. And in fact, in my own area, there in the southern Ontario regions of what's now called the Bruce Peninsula or the Saugeen Peninsula, there were historic Métis communities from the 1700s onward in places like Southampton and Owen Sound and Goderich and Port Elgin, all the places of major rivers. There would be settlements there, and with those settlements there would be intermarriage. With that intermarriage, new cultures would develop with their own laws and ways of dealing in the world.
Question on name. Would they also be called Métis if they were English?
So initially on the Red River side, if you were French and Aboriginal, you were called Métis, and if you were English and Aboriginal, you were called half-breeds. That was the particular language that was given in that colony, or the Red River settlement area. But outside of that, the language could be varied. All again, these people had their own words for themselves. I can't maybe point to the exact word here, but it was in the readings, which means independent ones. Something like Ote Pimisuak, which is like those who have their own hearts. And so, they in their own language, there was ways of being able to describe, as well as the application of ideas like Métis or half-breeds. Not only was, though, these settlements around the Great Lakes and on the prairies in Labrador, there was for quite some time a strong claim of Métis people being in that area, as there was intermarriage between Inuit and traders that were coming across from Europe. And likewise, there are claims to being Métis in every province in the country. It has been more difficult judicially speaking, to establish Métis under this second definition in Nova Scotia, New Brunswick, Prince Edward Island, Newfoundland, and British Columbia. I have a student, Carrie Sloan, who's working on her PhD here at this school, who makes very strong claims that there were independent Métis communities that developed here, some of them having a connection to the Red River settlement, but some of them just being a product of their own genesis with a self-identification, an ancestral connection, and community acceptance. There are also Métis communities in the north. In particular, there's a group out of the Northwest Territories that is negotiating as a Métis community with the Crown for the purposes of a land claims agreement. So you'll find those elements in various parts of the country. So those are two views, and sometimes they're quite at odds with one another. Sometimes you can find ways to reconcile them. There is a view that is a very nationalistic view from the Red River context that views other Métis peoples, so-called Métis peoples, as being interlopers, as not really having a right to be able to claim that name because they don't flow from that historic Western-based experience. And of course you can imagine how that feels exclusive to others who have another sense of their own identity, their own cultural connections. Here's a picture of that Métis diasporic community. We're going to talk about how that diaspora occurred in a moment, but you'll see you're basically dealing with the north shores of Lake Huron and Lake Superior through Manitoba, what is now Manitoba, Alberta, Saskatchewan, northern British Columbia, and a part of the Northwest Territories. You'll also note that that extends down into the United States as well. As I've already mentioned, that's where the buffalo hunt often ran. And in the United States, there will be Ojibwe or Chippewa communities there, but often a lot of the genesis of those communities in terms of their genealogy is a Métis type of genesis. So for instance, the Turtle Mountain Ojibwe of North Dakota have very strong Métis roots, or the Little Shell Ojibwe community in Montana also has very strong Métis roots. So this is one of those nations, like other nations that we've seen, that is divided by what some might consider an artificial border. So that's one view, that diasporic view. Another view is currently being considered by the Supreme Court of Canada in a case that was argued in October, which is Harry Daniels versus Canada. In October 29th, 2013, the Federal Court of Appeal found that Métis are Indians, as the term is used in Section 9124 of the Constitution Act 1867. But they didn't, contrary to what I've said here, non-status Indians were held not to be part of the decision. They weren't considered Indians for the purposes of 9124 in the Court of Appeal because the Court of Appeal felt there was no use to be able to include them in the declaration that was sought. At trial, the court found that both Métis and non-status Indians were Indians for the purposes of Section 9124. This is the case that I mentioned when we were talking about Inuit people that is kind of twinned with the Re-Eskimo case. Remember, Re-Eskimo was about whether or not Eskimos or Inuit could be Indians for the purposes of Section 9124. Now Métis people are coming forward and asking that same question of the court. They'd like to be considered Indians. That is, they'd like to consider that their relationship is with the federal government in terms of the obligations the federal government has in their affairs. Now, this argument has already been made. You can read online the facta of the different parties. You can also watch the webcast of the case. One of the issues, I want to pull out a couple of legal issues here. one of the legal issues is whether or not 9124 will be interpreted in an originalist type fashion. That is, will 9124 be given the meaning that it had in 1867 when the Constitution was passed? Or can 9124 have a meaning that grows with time and that departs from, perhaps, the initial meaning? So, you'll remember from first year constitutional law, the Persons case. In 1867, women were not eligible to be able to serve in political office. And then in the 1920s and 30s, they were appointed to the Senate. And then there was a question as to whether or not women could be persons such that they could be senators, because they weren't political persons at the time the Constitution was passed. And you might recall that at the Supreme Court of Canada, the decision was that women could not be persons, because that wasn't the meaning when the document was proclaimed to be Canada's Constitution. That was overturned by the highest court at the time, which is the Judicial Committee of the Privy Council. That court held that Canada, when it had its Constitution, had planted in it a Constitution which was a living tree, that new branches could be grafted on and added to that through time. So by taking that interpretation, the court found that women could be persons and therefore could be eligible to be called to the Senate, even though that wasn't the meaning of the term in that initial moment when the act was passed. Now here, in this context, we're asking, are Métis Indians at the time the Constitution was passed, or can we say, does it matter if they weren't Indians when it was passed because it can be a growing document? So here's what the trial judge said, accepting a living tree interpretation. I accept the plaintiff's submission that the purpose of approach, the living tree doctrine, is the appropriate approach, that is, understanding 9124 of the Constitution Act 1867. History helps us to understand perspectives on the purpose, but does not necessarily determine the purpose for all time. This is particularly the case with a constitutional power which has at some level racial tones, and which involve people who are seen in a light which today we would find offensive. Racial stereotyping is not a proper basis for constitutional interpretation. So the concern is that this judge says if we give Section 9124 the meaning it had at the moment that it was passed, we're basically freezing in time a view of Indians that is going to be a subordinate, and the federal crown will be dominant in relationship to those powers. Not only that, we'll be putting into law a racist, racialized way of thinking about Indians that only regards them as somehow being racialized, like Indians were regarded as being racialized at the time. This obviously has been argued at the Supreme Court of Canada now. Most of the Aboriginal parties followed this point of view. They wanted to reaffirm what the trial judge said and regards Section 9124 as being part of Canada's living tree. And so the AFN and the Chiefs of Ontario, the different groups took that line. But the Supreme Court but the Government of Canada took a different view. They wanted to see originalism as how this right should be maintained. So they say the living tree analogy cannot be the basis for ignoring the clear and uncomplicated words used in the Constitution. Nor does it justify judicial imposition of new obligations foreign to the original purpose of the provision in issue. Self-identification does not assist in the interpretation of Section 9124 because this section does not seek to define the term Indian, but rather defines an area of legislative authority. And so you can see here, they don't want to see Métis as a part of Indians. They view Métis as being distinct from Indians at the time the constitutional provision was passed. So that debate is going to come to you in the next 6 months or so when the Daniels case is decided. Another issue is whether or not the province should have a role in dealing with Métis rights, even as the federal government has a role in recognizing these rights. Here's the government of Saskatchewan's submission in Daniels. They say that even if Métis are to be considered Indians for the purposes of Section 9124, and incidentally, the Saskatchewan government wants to make that point, that they're both Indians for the purposes of Section 9024, but they, like all people in the province, including status Indians, remain subject to provincial jurisdiction under 92 of the Constitution Act of 1867. It is submitted that this means that the provinces can enact laws that specifically address Métis issues in certain circumstances. In order to be constitutionally valid, it is submitted that such laws must satisfy the following criteria. So what you have here is a follow-along, in Saskatchewan's view, from the Grassy Narrows case. Remember, there's one constitutional story that says only the federal government that should deal with Indians. There's that other story that's emerged, though, through Grassy Narrows and prior, that the provincial government has a role there as well. And here's how they say that the provincial government should have a role, which is, as long as the provincial government is enacting laws to related to Indians, that also is related to one of the heads of power under Section 92 of the Constitution, right? So it has to be pith and substance within Section 92 jurisdiction. The Métis specific aspect of the law must be sufficiently integrated into an otherwise valid provincial legislative scheme as per the court's directive in Kitkatla. And we're going to be talking about federalism next week and understanding more about what's meant there. Furthermore, third, the law must qualify as an ameliorative measure under Section 15.2 of the Canadian Charter of Rights and Freedoms as per the Cunningham case, which we're going to look at the end of this class, and the CAP case. And then four, if Métis Aboriginal rights are engaged, the law must either not infringe the right or must be justified under the test laid down in Sparrow. And finally, five, there must be no conflicting federal legislation dealing with the subject which would engage the doctrine of federal paramountcy. Now, I'm not a prophet, but I think there might be something in what's developed here that the court will find very attractive in finding that Métis are Indians for the purposes of Section 9124, and yet at the same time there's a role for the province to be able to deal with them simultaneously with the federal government. And of course, if they're both there on the same matter, the federal paramountcy would win out. The fact is that the federal government rarely does anything to recognize distinctive Métis rights. There's no Métis Act like the Indian Act, etc. There's very few recognition in treaties that Métis people have rights. So it's likely going to be the case that they will say that the federal government will have this authority under 9124. But it's kind of going to be empty in many respects because the federal government is likely continuing to be adverse to exercising jurisdiction over them. And so it's probably going to be the case, and this is the pathway that Grassy Narrows again is paved, that the provincial government will have a role to be able to deal with them. And you see that somewhat in the Cunningham case again, which we read for today. So those are the two issues that I see that are going to be live coming out of the Daniels case. There'll probably obviously be more, but one, what is the interpretive approach to Section 9124? And then two, what is the role for the provinces if there is a recognition of a federal power over Métis? Any questions or comments there? Yes.
Do you think that there was some sort of strategy in knowing that the federal government doesn't normally pass laws in relation to Métis people, that it would open up space for self-government? Or I'm just sort of confused as to what is the best result result in this situation?
Yeah, this is a good question. What is the best result in this situation? A lot of Indian people say to Métis, why do you want to be recognized as Indians? This has been a disaster for us because of how the legislation, the parliament has treated us in the country. What? Why do you want that? But the Métis people say, well, you have certain benefits that we would like to be able to receive because of your nation-to-nation relationship as we see it should be. And we would like to have treaties. From those treaties, we'd like to have jurisdiction and a recognized land base. We would like to be able to find ways to then fund our education, our health care, our other social services as families, to ensure that we're healthier as a community. So it's not quite clear what would be the best result for Métis. Is it good to be a part of Section 9124? I guess if they get those kinds of benefits, it would be, but it's not always been a great thing for Indians to be subject to federal jurisdiction, even though that is the older constitutional tradition.
Just a note on that. I'm a status Indian, and when I live off reserve, even though I'm still a status Indian, a lot of those benefits don't flow to me.
That's right. And so one of the questions is going to be, what is the scope of these benefits if Métis people do get recognized under 9124? And so this is the federal government might pass an act, highly unlikely, but might pass an act that tries to create a sense of the scope of that. And it may be that they are limited to a land base again. So as Métis travel beyond any particular land base that might be identified, they would just be like the point that Saskatchewan's making here, right? That there's a lot just in the general affairs of life that Indians and Métis people would be subject to just day-to-day provincial laws. Okay, so that's just my attempt to foreshadow to give you some future tools. Now let's look at this. So there's two views, right? Red River intermarriage. Daniels is trying to go down that second path of intermarriage to try to give some more meaning to Métis on that front. And let's look at the first path of diasporic Métis communities. Here's the Red River settlement in 1870. You see the English parishes that are outlined in red there, which are to the north and to the west on the rivers. Those are the people that were called half-breeds, that had English fathers and Ojibwe or Cree or other Aboriginal like Assiniboine mothers. Then you had the French parishes, which are in blue there, which tend to be in the lower part of the Red River, which is, again, the product of marriages that were French men, and then Cree, Ojibwe, Assiniboine, other Aboriginal communities. You can see it's a postage stamp of an area compared to the current size of Manitoba. The country, of course, came into existence in 1867. There was a provision in the British North America Act 1867 to be able to acquire Rupert's Land for the purposes of westward expansion of Canada. But when Rupert Land was acquired, the British Parliament insisted that Indian rights had to be taken account of in that westward expansion, because just because the Canadian government acquired Rupert's Land, they just basically acquired Hudson's Bay's claims to that land. They didn't acquire the land per se, because Indian people, Métis people, were still living there. So in 1868, the federal government, having got this law from the British Parliament at Westminster, started to make plans to survey what they wanted to call Manitoba. And in that survey, they were going to set up a government there that would be a part of provincial sphere. And as the surveyor was sent out from Ottawa, and as the lieutenant governor was sent out from Ottawa, the Métis people blockaded the entry of these figures into their homes. And into their homeland. And as part of this blockade, they said, you have no right to be able to set up your government here, to create Canada in this area without our permission, without our involvement, really without our consent. And so there was a controversy about whether or not the local powers could thwart and resist the national powers like this. It was winter time as this was setting up, and the Canadian government was hesitant to ask the United States government for aid in putting down what they're now regarding as a rebellion, a resistance of the Métis in this area, because there was very strong connections between what's called St. Paul and Minnesota. There's a lot of Métis people living in that area, and the United States in the 1870s and had designs on Canada. Right? It itself wanted to annex parts of Canada. So if Canada turned around and said, well, can we get passage through your country to go up and put down this rebellion, the United States would not say that. They would probably themselves maybe want to assert claims in this territory. And of course, you couldn't get troops out there at that time of year. And so there was a standoff, and the federal government had to be open to what the Métis people were saying here. And so the Métis people formed a provisional government. They formed their own government to set out a list of demands as to what they would like to see if they were going to enter into Confederation. And part of those demands were a provision of a Bill of Rights that the Métis people wanted to bring about. And in so doing, the provisional government then chose 3 representatives, none of them Métis, but with the Métis wishes in hand, to go negotiate with Ottawa. And this negotiation occurred, and then these representatives of the provisional government came back, and they presented the terms of what they were able to negotiate, and the provisional government accepted these terms. And next class, we're going to take up what the outcome was of those negotiations when we look at the MMF case, the Manitoba Métis Federation case, which is what we'll study for Wednesday's class. But what's important to note here is that Manitoba, and in fact, Western Canada, was ushered into Confederation as a result of Métis or Aboriginal involvement. This part of the country, particularly Manitoba, could not have been created in the way that it was created without Métis or Aboriginal governance being a significant part of this. Right? Otherwise, they'd stop the people from coming in. There were other complications that developed in this time as the Métis government was exercising power. Someone was put in prison who was a very strong Orange or Protestant supporter, and eventually this became, back in central Canada, as interpreted, it was a conflict between Protestant rights and Catholic rights. You probably know what happened. The Métis people didn't get what they negotiated for in this arrangement. The lands weren't set aside in time to be able to create Métis homeland and give them a head start. And so people started to disperse as as settlers from basically Ontario and England came into the territory. And so some of that dispersal took Métis people north into Manitoba, some south, as I already mentioned, in the United States, and then many out west along those old buffalo trading routes. Because even though they had their farms in the Red River area, of course, they had a good knowledge of what was further west of that territory. And so you have the development of Métis communities throughout the western provinces that are diasporic because they couldn't get their land properly set aside in the Red River colony. Eventually, they were pushed so far that in many respects they thought that their rights were going to be totally overrun unless they made a stand. And so what you get in 1885 is a Métis rebellion against this continually pushing them out of their homelands. And here's a map here with different theaters of operation during the 1885 period, when there were skirmishes and war between the Métis and the Canadian government. The Métis people, their view was they were pressed, their backs up against the wall, their promises that they received from the federal government not being fulfilled. The Canadian government's view was that these people were just treasonous, right? They weren't following law like the other people that were settling out across the prairie. In Batoche here, which is north and east of Saskatchewan, there was a battle where some settlers were killed, some Métis people were killed, and eventually with this Canadian Pacific Railway line, troops were able to be sent out, and this battle eventually went against the Métis, and they were in one way defeated there at that location. As a part of this, Riel was taken into custody and eventually tried for treason and hanged. And there's a lot of controversy around that trial and whether it was just a political show trial and whether or not it was moved away from places where he wouldn't get a jury of his peers. Similar Métis people, it was a place, Regina, where there wasn't Métis people settled at that time. His defense by his lawyer was that he was insane, that he was mad, that he wasn't therefore culpable for the actions that took place on the battlefield and heading up the Métis. But then he took over his own defense, spoke for himself and said, I'm not insane, and tried to proclaim what his vision of Canada should be, which was a Métis vision of Canada. He wanted to see people intermix from all parts of the world on the prairies, but that it would definitely have a Métis character in the way that that mixture would occur. And you'll see, I've got some clips that you can listen to and watch if you're interested in following this further. Incidentally, not only was he hanged, there was Aboriginal Indians that were also put in prison at this period. And this is my favorite National Film Board clip ever. If you've got 10 minutes at one point, you want to watch something called The Ballad of Crowfoot. It's like a music video. It's a 10-minute long folk song from the late 1960s, early 1970s that chronicles not only the Indian resistance and fall back on the plains, but also the Métis involvement in those disputes. So any questions or comments about that history? I know we went over a lot of history.
I won't say much. I was working for the National Film Board with Willie Dunn when this one was done, and he wrote the song.
Willie Dunn is a spectacular, Mi'kmaq artist, and not only did he write this song, he's written amazing songs about residential schools and white paper and all of those things that were happening during this era. It's quite an astonishing piece of work. In fact, I think we should watch it. Hopefully I can pull it up here. And as we watch it, this actually folds back many of the things that we were talking about too when we were dealing with treaties. This history that's going to be shown here is also a treaty history, and we're not going to get to this now. Maybe just as we were talking about that, another part of the Métis history so try to listen to the words. The guy does tell a story. It is the Ballad of Crowfoot. It is the history of the Métis and Cree and Ojibwe and Assiniboine, etc. on the plains.
comes the spring, and its warm thaw. Around your neck, the eagle claw. Upon your head, the buffalo horn. Today a great new chief is born. So raise them fast towards the sun. A heart now beats, a life's begun. It's 1821. Today a Blackfoot soul is born. Rover, why the tears? You've been a brave man for many years. Why the sadness? Why the sorrow? Maybe there'll be a better tomorrow. Your years have gone, the years have passed. Your heart is set, your soul is cast. You stand before the council fire. You have the mind and the desire of an ocean's wise. You speak so well, and in brave deeds you do excel. And it's 1853, and you stand the chief of convention. brave man for many years. Why the sadness? Why the sorrow? Maybe there'll be a better tomorrow. The years gone, the years have flown, the nation since has swiftly grown, but yet for the Indian, it's all the same. There's still the hardship, there's still the pain, there's still the hardship, there's still the strife. It's where it shines like day when at night. There's still hypocrisy, and the hate was that in the treaties, that they were all unhappy pawns in the government's game, and it's always the Indian who gets the blame. It's a problem which money can never lessen, and it's 1967. Crowfoot, Crowfoot, why the tears? You've been a brave man for many years. Why the sadness? Why the sorrow? Maybe there'll be a better tomorrow. Maybe one day you'll find honesty instead of the usual treachery. Perhaps one day the truth shall prevail, and the warmth of love which it doesn't tell. Crowfoot, Crowfoot, why the tears? You've been a brave man for many years. Why the sadness? Why the sorrow? Maybe there'll be a better tomorrow.
So, pretty powerful. I really do think that covers a lot of what was happening in this period. And you might have noticed there was a lot of clips of the Riel Rebellion. The trial of Louis Riel was interspersed in that. The fact that the treaties were being broken and people were being pushed off the land is also what's being said by the Métis. They view that agreement that they made in 1868-69 that led to the Manitoba Act as being a treaty with the federal government. And the failure to set aside those lands, and then the diaspora that they've gone through, they regard as being a breached agreement, just like Crowfoot and his compatriots also felt in regard to their treaty promises. There's a statement that Crowfoot made about life. I don't know, Lindsay, if you can find that statement. He really, in this period, became quite a philosopher, and people would turn to him to try to understand not just Indian, non-Indian relations, but to also try to understand how to live well in the world. And there was a lot of examples that Crowfoot set that were really what we would today call, about reconciliation and trying to make a better place despite the hardship that was acquired. What was his quote about life?
He says, "What is life? It's the flash of a firefly in the night. It's the breath of a buffalo in the winter time. It's the little shadow which runs across the grass and loses itself in the sunset."
What is life? Right. And it's just amazing the things that he talked about as he was going through these struggles. Well, the Métis people obviously were also through these struggles, and what happened is that they often were forced to live in the road allowances that the federal government surveyed, or the provincial government surveyed after treaty, and living in these road allowances, they could make their way. They weren't able to live on the Indian reserves with their cousins and aunts and uncles and grandmas and grandpas. So here they were in these places that were unsurveyed, or surveyed, but no one's living on them. And there was a woman named Maria Campbell who in the 1960s wrote a famous book called The Road Allowance People, which you can read about people's experiences. They thought they were just people in between. Right? They weren't able to live with the Indians on the reserves. They weren't accepted in broader community because they were, in quotes, tainted by their Indian blood. And so they weren't given the same status and capacities. As in, many Métis people tried to pass as not being Métis. They tried to pass as being white, and so a lot of these communities went underground, or for a few generations people would resist actively Métis identity because they didn't want to be treated in this way that we have presented to us. Last 2 weeks ago or so, I was in Saskatchewan. That Wednesday the class was canceled. It was a Canadian Institute for the Administration of Justice conference, and there was hundreds of judges from across Canada gathered in the Bessborough Hotel. And the Chief Justice of Canada was there, Beverly McLaughlin. There were many of the chief judges of many of the provincial courts of appeal. There were just a wide mix of judicial officers. And then there were presenters like me and other Aboriginal peoples talking about our views of the law you're learning here, but also Indigenous people's own laws. And Murray Sinclair, who is the past chair of the Truth and Reconciliation, got up and talked about Ojibwe law and what Ojibwe law means to him as a judge and how he sees its potential application from the bench. And then following that, there was a panel of professors and practitioners and deputy ministers that talked about their view of how Indigenous law could be used in contemporary Canada to give us access to dispute resolution, how we might better regulate ourselves. And I spoke briefly, and then after I spoke, Maria Campbell got up, and she took the entire afternoon. And in doing so, what she did was introduce the judges to Indigenous law by having them understand a trickster story, like a Nanabush, or they call the Sikajak story. And it was a play-acted story. So she stood at a podium much like this, and she had other actors that pretended they were her grandchildren. And as she was telling the story, the grandchildren would elicit issues, would help further move the action of the story along. And then as that was occurring, then there was this guy named Joseph Netahau, who was an amazing musician and artist, who then came and took the figure of this trickster. And so, you know, the grandma was telling the story with the children here, and then the trickster arrives on the scene. And it was the story of fraud and stealing and misrepresentation and broken promises. So it was an amazing story, but what was great about it was actually the first fart story. So where the first fart ever came from was what these judges were hearing in this very kind of formal setting in the Bessborough Hotel. You know, we have all these stories like how the skunk got its stripes, or the robin got its red breast, or the deer got its antlers, etc. Well, there's a story about where the first fart came from, and this is what was narrated. And I'm sure the judges sat there going, what have I got myself into here? How does this relate to my role as a judicial officer, an officer of the court? So this was told, and then another person came forward and started to curate a discussion about where the law was found in this case that was presented to them. And it was a wonderful moment for me, because all of these Aboriginal people in the audience started getting up, totally excited, and identifying legal principles and then correlating the principles with that in that story with other stories that they knew about, and being very specific in what the law was that was communicated there. And there were people there, you know, from Ontario to British Columbia, and there was interesting kind of coalescence of ideas. So I got up and spoke, and Val Napoleon and Ovid Mercredi and Jerry Moran, as the judge of the Cree Court in Saskatchewan, and Murray Sinclair, and just went on and on like this, and the judges were silent. They didn't know how to practice that kind of law. The tables were completely turned there, and it was just a visual representation about what it often is like for Aboriginal people to come to court and just not know how to deal with these laws that are so foreign to them. The shoe was on the other foot, and all these judges were suddenly having to deal with a foreign law. But I think in an appreciative way from what we heard as we went through the conference. Then that story finished, and then another story was told. This time there was no play acting involved. It was a story again of the trickster, and it was the story of how the trickster really desired his daughter sexually, and what he did to transform himself, faking his death and then coming back to life as someone else, as he represented himself, so that he can then lay with his daughter. And then the mother eventually finds out what her husband, the trickster, has done here, and what's happened with the daughter, and the steps that were taken did not turn out well for the trickster in that instance. Very different tone, right, than that first story, but very important for the courts to be able to hear that kind of story as well. And for the message is, right, that the challenges that Indigenous peoples have don't just flow from colonialism. Colonialism will have compounded those challenges in many instances and made them much worse. But in fact, we weren't anywhere near perfect prior to the arrival of Europeans, and part of our imperfections is that we had all of the abuses that humans can do to one another, including family violence, sexualized violence, as this story illustrated. And then, from that story, once she told it, people stood up again in the audience and talked about the legal principles that they narrated there in that story, and said, you know, we see resources for reasoning that are part of what's present there. And I really liked that too, because it wasn't romanticizing then what Indigenous law is. It shows that we did that to one another back in the day. That still happens to us even now. And the laws that are currently being used to try to deal with that are not so effective. And perhaps one other of those ingredients, and just not that ingredient alone, but one other of those ingredients would be our own laws to try to deal with those challenges. But here's this Métis woman that wrote this groundbreaking book in the 1960s about being a people in between. And perhaps it's part of that in-betweenness, that being lost between the borders of the nation, that saved some of the ideas and opportunities that can now be presented to Canadians and to our peoples anew, to be able to think about how we deal with the kinds of horrors that are part of our history now. I know you have no time during the year, but if you ever want a kind of an afternoon's read, this road allowance, it's called Half-Breed actually, I think, the book. She talks about her road allowance experience and the experience of her people in that regard. Any questions or comments about that? on a tangent there. I realize that hopefully you see it connected to trying not to ignore what the people are saying on the ground, right? They're trying to pull out the values of not only the Indians, but the Métis people in settling these affairs. So now we're going to be dealing with the Blais case and the Cunningham case. And they're an example, first of all, of not paying attention to Métis understandings and interests. And that's the Blais case, and then the Cunningham case, which more involves Métis people. So the Blais case, which is reproduced on page 643 of your materials, concerns these men here, in particular Ernest Blais, who went hunting in the province of Manitoba, and he was hunting during a time that was prohibited by the terms of the Provincial Wildlife Act. Mr. Blais, in hunting out of season, killed a deer, and then he was charged with killing this deer out of season contrary to the Provincial Wildlife Act, and his defense was that I am an Indian for the purposes of the Natural Resources Transfer Agreement, and Indians, under the Natural Resources Transfer Agreement, don't have any seasons. They can hunt at any time of the year in order to pursue their livelihood. So this is the facts there. Deer hunting, charged contrary to provincial law, and his defense. I have a constitutional defense. The NRTA protects me. So here's the wording of the Natural Resources Transfer Agreement. Wherever you read the word Indian, he wants to say this means Métis as well. So in order to secure to the Indians of the province, or the Métis, the continuance of the supply of game and fish for their support and subsistence, Canada agrees that the laws respecting game and forest in the province from time to time shall apply to the Indians within the borders thereof, provided, however, that the said Indians, or Métis, shall have the right, which the province hereby assures to them, of hunting, trapping, and fishing game and fish for food at all seasons of the year, and on all unoccupied crown lands, and on any other lands to which the said Indians or Métis might have a right of access. So here's what Mr. Blais is claiming here. He's an Indian which has the right to hunt, fish, trap at all seasons on all unoccupied lands. And so the question is whether or not the Natural Resources Transfer Agreement, whether Indians in that document can mean Métis. And the court comes to the conclusion that they cannot. That under the NRTA, Indians does not equal Métis. And so we need to understand how the court arrived at that conclusion. And first of all, they gave us an understanding of what the Natural Resources Transfer Agreement's purpose was as relates to this case. First of all, before the 1930s, all the natural resources in what became Manitoba, Saskatchewan, and Alberta were vested in the federal crown. And so if there's any development of forestry or farming or mining or oil and gas, all of that, all the benefits of that would flow to Ottawa. It wouldn't flow to the provincial capitals that were actually just being created in this period in some respects. And so here's Ottawa turning over to the three prairie provinces control of their natural resources. But the Crown, in right of Canada, had signed treaties with the Indians. And so Canada was concerned that if the province was going to take up natural resources, that it might do so in a way that would be to the detriment of Indians. So in order to protect the Indians' rights, as the crowns in the provinces were developing their lands, the Natural Resources Transfer Agreement sections 10 to 12 or 11 to 13, depending on the province you're on, protect Indian rights. Paragraph 11 says that there's an agreement between Canada and Ontario that will apply to Indian reserves. Basically, Indian reserves will still be dealt with by the federal government. Paragraph 12 allows for these hunting and fishing rights. The purpose here then, the object of the NRTA is to ensure that the pre-existing obligations that the federal government had towards Indians through the treaties were obligations that the province would then have towards Indians as they continue to manage those lands. Or as they started to manage those lands, not continue, as the provinces started to get the benefit of managing those lands. What are the guiding principles to understand? So this is a Constitution Act, 1930. And we have the Constitution Act 1867. We have the Constitution Act 1871 when British Columbia was created. We have the Constitution Act 1982, when the Constitution was patriated. This is of the same status. We're dealing with the Constitution of Canada. It just so happens to be 1930, a portion of it. And so in looking at the guiding principles, the court says this is a constitutional document in section 7, or paragraph 17, and it has to be construed generously, giving effect to the broad purpose that's guaranteed by the provision. Has to be placed in its proper linguistic, philosophical, and historic context. And then they draw on the Riel case. So they're, in other words, here's the signal. They're going to interpret the NRTA in the way that the Supreme Court interpreted Section 9124 in the Riel case. They're going to give the NRTA an originalist interpretation. Yes, it's generously construed, but it's construed in the context, philosophically, historically, that it was given at the time that it came about. And they're going to come to the conclusion that in 1930, Métis people were not considered Indians, and therefore couldn't be Indians for the purposes of these provisions. So they get there by looking at historical context, what are the prevailing views, and again, just like the Eskimo case, we're not asking the Indians as much, we're asking what did John A. Macdonald think? What did Governor Morris think about this? Then we look at the language, how are the Indians spoken of in the census documents? They were separated from Indians. They weren't included under the Indians when census were put together. And then here's the place where they do include the Métis view of themselves. When the Métis were the government of Manitoba, they talked about Indians in a way that it was different, and they talked about their own rights. And then finally, there's a consideration of the natural resources transfer objectives, which is the people were basically thinking about the treaties in drafting. These people sitting around the table, Prime Minister Mackenzie King and his cabinet and his provincial colleagues were thinking about ensuring that treaties were enforced and the Indian Act was not diminished as this transfer occurred. So that's the reasons for finding that you give this the meaning it had in 1930, no living tree development here. In fact, there were counter-arguments that you have to give section 35, you have to give the Natural Resources Transfer Agreement 1930 the same meaning that is given in the other constitutional documents whenever you talk about Indians, and including section 9124, and the court rejects that. They say Indians and Métis are separately enumerated in section 35.2 of the Constitution, and therefore they can't be considered Indians on that front. Secondly, they find there's no ambiguity as to what the meaning of Métis is. And then they reject the living tree principle. So this is in paragraphs 39 and 40. We decline the appellant's invitation to expand the historical purposes of paragraph 13 of the NRTA on the basis of the living tree doctrine. Yes, this court has consistently endorsed the living tree principle as a fundamental tenet of constitutional interpretation, but at the same time, the court is not free to invent new obligations foreign to the original purpose of the provision it issued. The analysis must be anchored in the historical context of the provision. Similarly, Binney emphasized the need for attentive to context and says that generous rules of interpretation should not be confused with a vague sense of after-the-fact largesse. In other words, if you were to interpret Indians, Métis as Indians here, this goes beyond the initial context too far. This would be vague after-the-fact largesse. Now, you could say in the person's case that making women persons such that they'd be qualified, just as the Senate could be vague after-the-fact largesse, but the court doesn't take that approach here, and so Mr. Blais loses. Métis are not Indians for the purposes of the Natural Resources Transfer Agreement. So now the Daniels case is coming forward, and this court says we take no position as to whether or not Métis are Indians for the purposes of 9124, but this argument has to be dealt with in the Daniels case when it's decided in the next 6 months or so.
So there's a part in the Indian Act where you can regain your status if before
85?
yeah, your grandparents or great grandparents lost their status because of marrying outside of your community.
In fact, this is the next case, which is the Alberta and Cunningham case. Here you have 8 Métis settlements in northern Alberta that were created under provincial statute and amending the provincial constitution to recognize that Métis people have rights under the agreements that the Métis people have with the provincial government. And the issue here is that someone, Mr. Cunningham, gained status under the Indian Act, because you could do that after 1985. But he still wanted to be Métis for the purposes of living on these settlements. He said, I can be Métis and Indian at the same time. That's what we always did. And so his claim is that it's a violation of the Charter of Rights and Freedoms for him to be denied as an Indian the opportunity and ability to live in the Métis settlements and participate in Métis governance. He says, my charter rights are being violated. The court says, no, they're not. The court comes to the conclusion here that the creation of Métis settlements is an ameliorative program under Section 15.2 of the Charter, which distinguishes Indian and Métis people and allows Métis people to control their own affairs. And Indians, if they were to be included in that, would erode that governance, would erode that special ameliorative program that's created by the province here. Now there's YouTube clips that you can watch again about these Métis settlements. There's a history of the settlements that's outlined in the materials. Basically, these Métis communities are part of these diasporic communities from the Red River. But there was never any land that was set apart for them. They were road allowance people. But during the Depression, in the 1930s, here a commission was set up to try to create a land base for them. And there was an act that helped to secure some of those benefits in 1955. And then in 1989, there was negotiations between the Métis people and the provincial government to turn over those lands to Métis people in fee simple, to give them a right to be able to govern those lands. They have courts to resolve disputes in relationship to land and membership and economic development, etc. And like I said, the Constitution of Alberta was amended, as well as making this a statute. And you can look, if you are more interested, about the Métis Settlement Organization here. It's the only place in the prairies where we have something that's akin to like an Indian Act structure, except this is held by fee simple. And you can actually look at all the cases. There are tribal courts in Canada. These are Métis courts. And these Métis courts have a jurisprudence. You can read their decisions. You can see how they apply not only what's in the statute, but their own distinctive legal reasoning and community values. It is true that they can be appealed. These agreements of the Métis Settlement Appeal Tribunal can be appealed to the Alberta Court of Appeal. The Court of Appeal has been pretty good at being deferential to these Métis courts. Always run out of time, don't we? So why is this protected under Section 15.2 of the Charter, the Métis settlement regimes? First of all, it's assumed that the Métis people are an analogous ground under Section 15 and therefore can claim Charter protection. They then look at the purposes of the Métis Settlement Act as an ameliorative act which helps to advance Métis self-government. Self-government here is protected under Section 15.2 as a valid ameliorative objective. And then the distinction of saying that Indians can't live on the Métis settlements serves an ameliorative purpose, which is it recognizes Métis uniqueness. It allows self-government to be more fully invigorated. It facilitates the standardization and the identification of Métis membership. So the bottom line is that Métis settlements are protected under the Charter as self-government regimes. And Indians can be denied membership, participation in this. On the one hand, that's great for the Métis people. On the other hand, it's caused a lot of problems because they still live as Indian and Métis. And so it's kind of broken the communities up in some way because they want to be members of both community. On the other hand, there are people that like this, that say, this protects our spot. Here's one issue that arises from this for me. Could Aboriginal self-government be further recognized, created, developed under Section 15.2 of the Canadian Charter of Rights and Freedoms? We've been talking about Section 35 as a ground for governance, but what if British Columbia said, we want to recognize Aboriginal communities' self-governing powers just like happened here with the Métis people. So we're going to distinguish them from other Canadians. We're going to say this program to recognize self-government is going to advance them in their affairs. They can have courts and governments and social services, etc. And that this distinction recognizes Indian uniqueness in British Columbia. That uniqueness is realized through self-governance, and it's done through consultation, self-organization, and standardization. I'm sorry that I went so fast through that, but this is kind of new. Wondering whether or not the province has a role in the facilitation of self-government. If you combine the slide that I put up earlier, that under Daniels, the Saskatchewan government was arguing that we can have a role in Indian affairs. What if that role is actually what Alberta has done here in supercharging those sets of communities? We're going to continue our discussion of Métis next class when we deal with the MMF case. So please come prepared for that. It's on the Supreme Court website. At least read the head note and certainly the majority judgment you get.